Good morning, Council. We'll try it again. I think we're ready to roll now with the Kansas Court of Appeals docket this morning, meeting by Zoom. My name is Catherine Gardner, and I'll serve as the presiding judge this morning. And largely that means that I'll be keeping track of your time. Our first case is set for 20 minutes. So when appellant begins argument, please let me know if you'd like any rebuttal time. Sitting with me today are Judge Schroeder, who is on your left, my right. He has been with the Kansas Court of Appeals since 2013. Before that was a district court judge in southwestern Kansas. And also sitting with us today is Richard Walker, who is a retired judge from the Newton, Kansas area. And he's been sitting with the Court of Appeals as one of our senior district judges for quite some time. So with that, we will go ahead and call the first case, which is number 122500K Auer, Appellee versus Waterwalk International, LLC, Consolidated Holdings, Inc., and Jack P. Deboer. I'll go ahead and take appearances, please, and then appellant, you may begin.
Yes, good morning, Judge. This is Clayton Kaiser of Holston Seakin. I represent Waterwalk International, LLC, Consolidated Holdings, Inc., and Mr. Jack Deboer, who are the defendants appellants in this matter.
Thank you.
Good morning, Your Honors. Derek Casey with Triplet Wolf Garrettson. I'm privileged to be here on behalf of the plaintiff appellee K. Auer this morning.
Very good. You may go ahead and begin, Mr. Casey.
May it please the court. This is an arbitration case, and as such, there's essentially two key questions that the court must resolve here today. First, the question is whether or not an arbitration clause or provision exists between the parties. And then second, what is the coverage and does it extend to the particular dispute between the parties now at issue?
And Mr. Kaiser, before
Yes,
you address those, would you like any rebuttal time today?
I would, ma'am. May I reserve 3 minutes?
Very good. Thank you.
Thank you, Your Honor. So there are, again, two questions. The first question, whether or not an arbitration agreement or provision exists between the parties is not really contested in this matter. Ms. Auer, as well as appellant's defendants, agree that there are at least two arbitration clauses that could be at play in this litigation. So therefore, issue one really is one that should not concern the court. The one that may take a little more involvement from the court is the second question. That's regarding the extent of the arbitration agreements that are potentially at play here. Again, I think that the parties are in agreement that there is an arbitration provision in the side letter, which we referenced extensively in our briefing, as well as an arbitration provision in the operating agreement.
Well, counsel, this is Judge Schroeder. Tell me where in the side agreement it calls for arbitration of a wage dispute.
Yes, Your Honor. I would point Your Honor to two things, and specifically, this is pages 42 through 44 of the appellate record. And the first provision that deals specifically with arbitration would be paragraph 3, Judge Schroeder, which is on page 43, and that is the repurchase agreement provision. And there specifically, there's an arbitration clause. That is one avenue. The other avenue.
Well, okay, while you talk, let's talk about that paragraph a minute first. All right. The first part of that paragraph talks about arbitration involving the repurchase of the assets of interest in Waterwalk. Is that correct?
That is correct, Your Honor.
All right. And in the last sentence, it talks about at the conclusion of the arbitration, all wages due and owed would be paid to her. Isn't that more of a accounting process than an agreement to arbitrate that issue?
I understand your question, Judge Schroeder, and I'll answer that. But before I do so, I want to, again, for the court's, I guess for purposes of argument, again, there's three key documents here. The first would be the offer agreement that was given in October of 2014. Then the side letter that Judge Schroeder just referenced, and then the third would be the operating agreement. And when we're looking at the side letter, we can't look at it necessarily in a vacuum, but rather in that context. And I agree with Judge Schroeder that the arbitration provision is housed in the repurchase agreement paragraph. But the way that, again, that's not necessarily my key argument, but how this fits into the defendant appellant's argument here, Judge Schroeder, is that it makes clear that what the parties intended was that all disputes be resolved through arbitration. We get that crystal clear through the operating agreement, and that's reinforced in the repurchase agreement. Because again, as Your Honor points out, obviously the preface or the buildup and arguably the thrust of paragraph 3 is focused on the repurchase of Ms. Auer's ownership interest. But as you go on, and you quoted from Judge Schroeder, it says all amounts due for unpaid salary and guaranteed payments for debts and obligations, and all amounts due by the company to you will be paid, settled, or offset as part of the repurchase transaction at the closing. And so it's not, as Ms. Auer, at least my understanding of her argument, is that essentially you can bifurcate these processes. And what the parties intended, as made clear in the side letter, is that this all be rolled in to one forum, one action, and that action take place in arbitration so that we can resolve the guaranteed payments, which is what Ms. Auer is claiming that she's entitled to in this litigation. If you look at her petition and in the briefing of the parties, she's not claiming anything from that initial offer letter. Rather, what she's claiming all stems from the side letter. And so, again, I understand Judge Schroeder's question and sort of the thrust of it, but what I would say in response to that is that basically it's focused on the fact that the parties want to resolve all their disputes in one forum. And that's the first provision. The second provision, Judge Schroeder, that I think is actually more important in this litigation is the paragraph 8, which is on page 1 or page 44 of the appellate record. And it says the definitive agreement, that's quote, definitive agreement shall be the operating agreement, and that shall govern except in those cases where you have specific conflict between the side letter and the operating agreement. And I can give Your Honor one example and why potentially I can understand the court may have a question. Well, the repurchase agreement talks about arbitration and there's no other arbitration provision in the side letter saying that all disputes in addition to repurchase agreement will be settled through arbitration. Then aren't you essentially asking counsel for us to read out the repurchase agreement arbitration provision in the side letter? And we are not, Your Honor. What the side letter does is it gives Ms. Auer a special right that she otherwise would not have been entitled to. If you look at section 1005 on page 95 of the appellate record, which is section 10.5 of the operating agreement, as well as section 12.01, it talks about how members, which is what Ms. Auer is, in Waterwalk International LLC, how their ownership interest will be valued. Specifically, section 10.5 says that you have no appraisal right. So essentially, whatever value that Waterwalk would assign to that ownership interest, Ms. Auer, but for the side letter, would be required to basically accept that. She would not have an opportunity to contest that and challenge that in any forum. And so the side letter agreement, repurchase agreement provision specifically gives her a right that she otherwise would not have had as a regular member in the LLC. Secondly,
can I ask a quick question? Am I correct that Ms. Auer is not claiming any amounts due to her under the repurchase provisions themselves? Is that correct?
At this point, Judge, it is not, is my understanding that there is no dispute for the parties with regard to that, with the repurchase agreement amount at this particular point.
Okay, so she's not saying, hey, you owe me money under the repurchase agreement in any way at this point in the case. Is that, I thought it was just basically a wrongful termination, lost wages kind of issue, not a repurchase dispute at this point. Am I correct about that?
Sir, you are correct on the characterization with respect to her claim. Now, how this fits into the repurchase agreement arbitration provision is it says specifically all amounts due for unpaid salary and quote, guaranteed payments, end quote. Guaranteed payments, as the court knows, is a term of art. And specifically, that is what Ms. Auer is claiming in this particular case. She is claiming guaranteed payments, which is what the side letter specifically references in paragraph 4, which is on page 44 of the appellate record. And the agreement uses the term guaranteed payments. Guaranteed payments, as the court knows, is a term of art that basically says that when members provide services to the LLC, that they're going to receive basically first-tier distributions for that amount. And so when they use that term guaranteed payment, we can't basically conflate or raise to the level of that being equal to wages, because it's not. It has a specific meaning in LLC and corporate law, and that fact further, supports the notion that, again, contrary to what Ms. Auer is intimating, that she remains an employee and she remains an owner. And on another hand, those two identities basically merge, and you can't separate the one from the other. And so,
but counsel, the repurchase of assets, her interest, is separate from guaranteed payments, is it not?
It is, Your Honor.
All right. And are the guaranteed payments a set amount in the contract, or are they something that's determined based upon profit of Waterwalk?
No, and Your Honor, that's a good point. That's with the guaranteed payments, that's a first tier distribution. And so she receives that regardless of the income for the LLC.
All right. So those guaranteed payments aren't in dispute.
Well, they are in dispute, Your Honor, which gets to a factual question. As you read through our answer, our position is, and that's how, again, further evidence of how the operating agreement.
Let me back up. I don't
Yeah.
see the guaranteed payments being an issue in dispute that's in the briefs.
At this particular point, it is not, Your Honor. The reason I raise it is because right now we're at sort of the infancy of the case. We're determining what forum is appropriate. What is in the record, Your Honor, is our answer. And if you look through our affirmative defenses and our other defenses, our defenses are that that Ms. Auer was not entitled to the compensation or to the guaranteed payments that she's claiming, and then B, that she had not performed. And those questions are all interrelated with the operating agreement. Ms. Auer wants to basically tell the court that every responsibility and obligation and duty that she had is set forth in the side letter, and that's simply not the case. Again, pointing Your Honors to paragraph 8 on page 44 of the appellate record, it says that the operating agreement will be the definitive agreement. And when you go to the operating agreement and it talks about CFO duties, which is paragraph 6, it's section 6.02, paragraph F, which is on page 79 of the appellate record. It has a whole litany of additional obligations and responsibilities that Ms. Auer, as an officer of the corporate or LLC, irrespective of her ownership interest, that she must meet. And also, importantly, Judge Schroeder, it says that the chief financial officer will have such other powers and perform such other duties as may from time to time be prescribed by the chief executive officer, the president, or the manager, which in this case is Mr. Jack Deboer, Your Honor. And so wrapped up, again, at this point, we haven't made our defenses because the case is at the infancy. But as you see through our answer, all defendants have raised those defenses, and those are going to be part of this case when it goes forward. And so for us to say that the operating agreement has no play at this juncture, I would say, Your Honor, loses sight of the fact that the operating agreement, which is specifically referenced in the side letter, is to govern and sets forth the duties and obligations that Ms. Auer would be held to. But, Your Honors, I want to get back to sort of the main thrust of our argument, which is
Before you do, let me just clarify one thing. Normally, when we see this type of arbitration argument early in the case, it's because there is a written contract of employment that has an arbitration clause in it. Does Ms. Auer have a written contract of employment?
She does not, Your Honor.
Okay.
Basically, again, Your Honor, the three agreements that we have are the offer letter from October of 2014, the side letter, which was basically signed in October of 2015, but backdated to October of 2014, and then the operating agreement. Those are the three operative agreements, Your Honor. Again, first agreement, it's our position, basically provides context, but nothing else. Her claims are not based on that. But I'd like to focus the court here on the operating agreement, which, again, that's sort of the thrust of our argument here. And before I get to that, just pausing very, very briefly with respect to the applicable law, which obviously is very important. We need to make sure that we're all we're all on the same page with respect to that. As Judge Comer did in the district court, he asked the parties, specifically the defendants appellants, to have Mr. Deboer submit an affidavit basically highlighting the interstate commerce nature of Waterwalk LLC, which we did. And that was uncontroverted. As set forth in there, I believe that Mr. Deboer said that, again, we're involved in the extended stay business, that we have franchises in 9 states, that we have investigating opportunities in 5 additional states, that we manage long-term or long stay businesses in 4 additional states. And as well, in her petition, Ms. Auer alleges that she worked on projects in 2 different states. And so what we're dealing with here, and this dispute is governed by, is the Federal Arbitration Act, Your Honor, as this involves interstate commerce, and has been interpreted in the cases that we cited, Hague versus Hallmark, Packard versus Credit Solutions. This case is governed by the FAA, and therefore the views with respect to all doubts being resolved in favor of arbitration, and that really the only basis on which the court could find that a case should not be arbitrated is if it's not susceptible to that interpretation. So it's a very favorable policy in favor of arbitration, and recognizing the strong national and state interests we have in arbitration. And so that's sort of the background. Turning specifically, Your Honor, to the operating agreement, obviously there was a lot of ink spilled between the parties with respect to what's sort of the proper interpretation for the court when determining one agreement's arbitration provision, whether or not it should supply or govern a claim that arguably rises from a different agreement. And in preparing for this argument, counsel came across the case that I think basically synthesizes the case law in a very digestible, easy to sort of understand way. And that's Hemp Hill versus Ford Motor Company, which is 41 Can App 2D 726. And it's a 2009 Kansas Court of Appeals decision. And in there, the court said that there are essentially 4 factors you look at. The first is, does the one agreement reference the other one that has the arbitration agreement that one party is seeking to enforce? The second is whether or not they relate to the same subject. The third is whether or not there's any exclusionary language in the arbitration provision that the party is attempting to enforce. And then fourth, you're looking at the timing. And we set forth a lot of these arguments, but I think this kind of sets it forth in a very digestible way. And when you look at 3 of these 4 factors, the reference, the exclusionary language, and the timing, those all cut in the appellant defendant's favor. There's a specific reference. In fact, the side letter characterizes or describes the operating agreement as the definitive agreement. With respect to the exclusionary language, it's hard to imagine a more expansive arbitration provision than is found in the operating agreement, to where it says, to the maximum extent allowed by or permitted by the law, as well as to all claims and or relating to the operating agreement.
I'm going to ask a stupid question. I don't know who drafted these documents, but I'm sure they were paid a lot of money to do so. But wouldn't it have just have been simpler to have a clause saying all disputes under this agreement, and this agreement between the parties shall be subject to arbitration? Wouldn't that have meant we didn't need to be here today?
Respectively, Your Honor, what I would think would happen in that case, because it would, in my mind, my estimation that would be redundant. What we have here is we've got paragraph 8 of the side letter that says we're going to reference the operating agreement. So that basically supplies the baseline for the parties going forward. And so at that point, to say that we've got a baseline and then we're also going to supplement the baseline's already very expansive arbitration provision, it could have been done, Your Honor. I agree. I don't necessarily think it's bad draftsmanship not to have included it. And Your Honor, further, what I would also point, Your Honor, to is when we look at the repurchase agreement deals with something very specific, which obviously Ms. Auer could be concerned about if for whatever reason her relationship with Waterwalk does not work out, which is the repurchase of her 5.2% ownership interest in the LLC. Again, the operating agreement sets forth a different sort of policy and a plan. Basically, you have no appraisal rights. At that point, Ms. Auer basically be stuck with whatever Waterwalk proposed as the fair market value for her ownership interest. What they gave her, though, in the operating agreement to deal with that specific contingency is the repurchase agreement, which gives her this forum in arbitration to air her grievance and to have what she views to be a fair valuation of that ownership interest. And so, again, I don't think that there's no need to have a provision dealing specifically with the employment or the CFO responsibilities, Judge, and because that's already covered with the operating agreement. Where there was an inconsistency, or at least an inconsistency that could arise in Ms. Auer's favor, that's when the parties put a very specific arbitration provision. And if you look at this, again, as I was talking to Judge Schroeder, I think this reinforces our argument that the parties intended for this to be wrapped up into one big box and to be settled by an arbitrator, because it doesn't just merely say you repurchase, when we repurchase your interest, we are going to have that decided by an arbitration. No, they lump in every other sort of liability or expense that could be shared or in controversy between the parties into that single action, that single suit. And so I think, that the repurchase agreement just is further evidence with respect to the parties' intent, which again, underlying all this is basic Kansas contract law, but that does not usurp or overcome the arbitration law, which already says when we read through these provisions, unless it's clear that the parties did not intend arbitration to cover this specific dispute, then we're going to have arbitration to cover that dispute.
Counsel, you're getting into your rebuttal time, which you're welcome to do.
I'm sorry, I have one more question, Counsel.
Sure.
All right, so tell me in what paragraph of the operating agreement it requires arbitration between the LLC and an officer for wages of.
I will admit, Judge Schroeder, that there is not a provision with that specific language. What I would say is that there's the all-encompassing section 7.04, or I apologize, it's section 7.05, paragraph A on page 85, where it says to the maximum extent permitted by law, which again, under the FAA, employment law disputes can be handled in arbitration. The parties mutually consent to the resolution by arbitration and not litigation of all claims. Again, if they intended to cabin and carve out, maybe they could have included a provision in the side letter that says, despite the provision or the all-encompassing arbitration provision in the operating agreement, we are going to carve out employment disputes, and that will be resolved, through typical litigation or through the court system. They did not do that, Judge Schroeder. So I would point your honor as well as the court to section 7.5 and to its all-inclusiveness to argue that arbitration should be had on all the claims in this lawsuit. Thank you.
Thank you.
Kathleen.
May it please the court. There are 3 points that I'd like to discuss with you today that I believe will assist you in deciding the issues that are presented here, and also show the sharp disagreement between the parties as to the record on appeal and as to the governing legal authorities. The first point is that Kay Auer had 2 separate and distinct relationships with Waterwalk. One was as an employee and another was as a minority owner. The second point is that the arbitration clauses in this case clearly state the parties' intent to arbitrate the ownership issues and not employment issues. And the third point, I want to talk about the law a little bit because it has the capability, due to some what could be perceived as inconsistencies in some of the case law over the last 10 years, of being misunderstood, and I believe it has in the context of this case. First, I'd like to talk about the 2 relationships that Ms. Auer had, and this gets to your question earlier, Judge Gardner. There is an express employment agreement between Waterwalk International and Kay Auer. The first employment agreement was executed in October 2014, and it is in the record, volume 1, beginning on page 296. It sets forth the terms and conditions of her employment, and it does not contain an arbitration agreement. That agreement was modified by the parties in October of 2015 when they executed the side letter agreement. And it is also an agreement governing her employment relationship. It sets forth what her duties are, it sets forth what her compensation is, and it also provides an avenue by which she can acquire a minority ownership interest in Waterwalk. So there was a written employment agreement, And those two written agreements, one of them does not have an arbitration clause, and the other one has a very limited arbitration clause that was discussed earlier, the side letter agreement, which requires arbitration if the parties, if Ms. Auer's employment is terminated, Waterwalk has to repurchase her ownership interest at fair market value. If the parties cannot determine what fair market value is, there has to be an arbitration. And they could not have been more clear. And again, these are astute business people. This is not stuff they got off the internet and just signed to go forward with. These people, this is a big business operation with people who know what they're doing. And the arbitration agreement in the repurchase clause, paragraph 3, says the arbitration will determine the value of the units / interest to be repurchased in an amount no greater than the highest initial offer and not less than the lowest initial offer. Consistent with that, the arbitrators have to be qualified to value companies engaged in the real estate development and franchising business. So that arbitration is clearly limited to just that one issue of determining what the repurchase value is. Waterwalk wants to twist that into the last part of that paragraph where they have a repurchase transaction. That is a closing of the repurchase. And instead of having to pay things out separately, the parties have intended that there be a closing transaction where any amounts owed between them are offset against that repurchase value. It nowhere gives the arbitrators jurisdiction to determine what her salary is owed, what her guaranteed payments are, what else is owed between the two of them. That's a separate matter from what the arbitration is. One more point on that, and Judge Schroeder, I think this gets to your question. I think Mr. Kaiser has a misunderstanding of the record. Turning to the 3rd page of the side letter agreement, which I believe is Record on Appeal, Volume 1, page 300, paragraph 8 does define the side letter agreement as the definitive agreement. The last sentence of that paragraph says, in the event of a conflict between the terms of the operating agreement and this side letter, the terms of the side letter shall control, not the operating agreement. The side letter controls if there's a conflict. It's critical to maintain this distinction. I'm sorry, I was talking about the side letter. Ms. Auer exercised her rights under the side letter and purchased her minority 5.2% interest, and in conjunction with that, executed the company's operating agreement. So we have two distinct relationships that are critical for this appeal, the issues presented. One, she remained employed as the chief financial officer for Waterwalk, and she acquired her minority ownership interest, which is governed by the operating agreement as modified by the definitive agreement clause of the side letter agreement. Her other relationship as his employee, as is under the terms and conditions set forth in the employment agreement as modified by the side letter agreement. The terms and conditions of her employment are not to be found anywhere in the operating agreement.
So we've heard earlier that the side letter agreement does contain a list of her duties.
Yes.
Would you say that any of her claims or any of Waterwalk's defenses in this case depend on that, the terms and conditions of the side letter agreement?
It depends upon the terms and conditions of the side letter agreement in regards to her employment relationship. Nobody has taken any step to go forward to repurchase her interest, which would be subject to arbitration determined value, or any other aspect of her ownership interests, which are distinct in the side letter agreement. Let me give you a hypothetical, Judge, that I think will illustrate this. Let's assume that Ms. Auer is employed by Waterwalk as the chief financial officer, subject to the 2014 employment agreement as modified by the side letter agreement. She's given an opportunity to purchase a minority interest and execute the operating agreement, but she declines to do so. And so she never acquires her 5.2% minority interest and never executes the operating agreement, excuse me. She continues her employment just as she did in this case for 3 more years as chief financial officer, and she's not getting paid as was agreed. And she complains to management that I'm not getting paid and this violates my rights under the contract and under the Kansas Wage Payment Act. So they fire her in retaliation. She files the exact same lawsuit we have here. Breach of contract, you didn't pay me my wages. Kansas Wage Payment Act, you didn't pay my wages, I'm entitled to penalties and interest. And retaliatory discharge for retaliating against me raising my rights under the Wage Payment Act. In that setting, where would we have to consult the operating agreement to determine the terms and conditions of her employment and what she's owed as an employee? In the briefing and up till now, up till the arguments this morning, Waterwalk pointed at 3 provisions in the operating agreement they say is relevant. Section 6.02A says the manager has authority to hire a chief financial officer and to fix their salary. Nobody disputes that Mr. Deboer was the manager and he had authority to do that, and he did that in this case. They point to section 6.02F, which generally describes the position of chief financial officer. The terms and conditions, her duties are set forth in her employment agreements, not in the operating agreement. It just generally defines the position. It doesn't establish K hours duties as chief financial officer. And nobody complains that she was acting beyond those duties as set forth in the agreement. So that's not at issue. It's not relevant. Finally, they like to point at section 6.13C, which says that officers cannot be paid absent a vote of a majority of the members. But the majority of the members is a term that's defined in there that's not a head count of the majority of the members, but who owns the most units, the total number of units, the majority. And that's Mr. Deboer. There's no dispute that. It's set forth in the operating agreement. So there's no dispute that he had authority to hire her, that there was authority to create a position of CFO, and that he did so. So in my hypothetical, where she never actually acquires her ownership interest, the operating agreement's totally irrelevant. Let's go back to what the record actually is. She did sign the operating agreement, and she did acquire a minority interest. How is the operating agreement relevant to her unpaid wages? They haven't demonstrated that. They have to show that her claims for unpaid wages arise under or in connection with the operating agreement. Now, there's been a couple of new provisions cited here this morning. Those arguments, those are new today. Section 12.01, Section 10.5, appraisal rights, but those were all dependent upon their interpretation of the operating agreement being the definitive agreement when the side letter actually says otherwise. Those arguments should be dismissed too because they were brought forward for the first time today.
Counsel?
Yes.
If she's entitled to guaranteed payments, is she receiving those guaranteed payments during the pendency of this litigation?
She has not received any guaranteed payments, to my knowledge. I don't think there's any evidence of that in the record, and to my knowledge, she hasn't received any guaranteed payments.
So once she was terminated, her right to any type of compensation has also been terminated.
I think that's accurate as to the nature of their agreements. I believe that's right, Your Honor, but I have not explored that as it relates to her ownership interest because we're not litigating those issues at this time.
Well, I just find if guaranteed payments is a term of art, they have a meaning. And apparently the parties aren't following that either.
Well, as I understand a guaranteed payment, it is a term of art relating mostly to reporting on tax matters, how you report income. So when you have an LLC member who's also an employee, they don't draw a salary in the traditional sense. It's reported on W-2s and W-4s. They are paid guaranteed payments that show up on the K-1. And that's the tax distinction that happened. It really doesn't have any relevance to what she claims that she was not owed per their employment agreements, whether it's termed a salary, which would be reported as a W-2 and W-4s, or whether it's termed as a guaranteed payment that show up on a K-1. That's where that distinction, as I understand it, and I'm not an expert on tax matters, but that's how.
So then that would make the guaranteed payment self-employment income instead of wages.
I think you could use those terms. I'm cautious because I want to make sure that I'm not, the term wages under the Wage Payment Act is really broad, and I don't want to step too far in and out of that.
I digressed a little bit. I
think for tax purposes, I don't disagree with your characterization for tax purposes.
All right, thank you.
Again, as I said, what is the relevance of the operating agreement under the wage payment claim if she would never become an employee, if she never had become an owner? It has no relevance. And even if she is an owner, it still has no relevance. Likewise, there's no relevance as to the arbitration agreement under the side letter agreement because it is restricted. It could not be more clear that arbitration is restricted to determining repurchase value. So it's not relevant. Two separate and distinct relationships. The arbitration agreements govern separate and distinct situations. Pull that language up. And I'm sorry, two separate and distinct relationships, and it's important that we remain mindful of those when we're looking at these issues. The second point is that these arbitration agreements could not be more clear in their statements. As we previously talked about, the side letter agreement limits the scope of arbitration to determine the value of the units and interest to be repurchased. It contemplates a closing transaction where offsets will be had, but nowhere does it give the arbitrators authority to determine unpaid wages. The operating agreement has a clear arbitration agreement. As Mr. Kaiser read, to the maximum extent permitted by law, the parties mutually consent to the resolution by arbitration and not litigation of all claims, causes of action, disputes which may arise out of or in connection with this agreement. Arise out of or connection with this agreement. In their arguments, Waterwalk has cited Williston on contracts, which is cited, I think, by both parties in their briefs. 57:21, 4th edition, where Professor Williston examines what that clause means. It means that the dispute has a significant relationship to the contract, such that the dispute cannot be resolved without reference to or construction of the contract, or the dispute has its origin or genesis in the contract. Waterwalk has contended that the first factor controls that Ms. Auer's claims and their counterclaims cannot be resolved without reference to or construction of the operating agreement. The portions of the operating agreement, they identified the portions I talked about earlier that are discussed in the briefing, have no bearing on whether she's entitled to compensation under an employment agreement as modified by the side letter agreement. We can look at some of the case law to help give us some guidance and instruction on that. Both parties have cited the Packard case, which was the dental practice that hired a consultant who later agreed under a separate oral agreement to provide martial arts training, I believe, to the staff. In that one, it was in the first written agreement, the parties agreed to arbitrate anything arising under this agreement and any other disputes between the party in the future. And this court had no problem in understanding the clear meaning of the language that the dispute must arise under the terms of this agreement. That was clear to the court. There was no need to go any further with it. For another example, we could look at the Packard case, which involves credit service agencies, a dispute on that, where the arbitration clause was limited to claims arising under the agreement, the credit services agreement. And this court had no problem in understanding what that meant. There was no doubtful construction of that. For a contrary example, let's look at the Hague opinion that Mr. Kaiser cited. In that one, that was an employment relationship. I'm trying to remember exactly what the type of employment was. I'm sorry, I don't recall. It's Hallmark, Hague versus Hallmark Cars. She worked for Hallmark. And the parties agreed to arbitrate any disputes arising in the course or context of the employment. And this court had no problem understanding what that meant and applying that arbitration clause to that case to determine that disputes regarding her short-term disability benefits arose out of and under her employment and were subject to arbitration. As I said earlier, we're not dealing with amateur parties in this case. We're talking about some very astute business people. If they wanted to arbitrate employment claims, they had ample opportunity to write that in the first employment agreement, in the side letter agreement, and take care of it, but they didn't. They expressed their intent to limit arbitration to ownership issues. The final point I want to make, and I believe I still have some time.
Yes, you have about 4 minutes.
Thank you. That'll be plenty, Your Honor. The law, some of the cases could be misread or misunderstood. I just kind of want to go over that, starting with the Anderson decision, the Kansas Supreme Court, which is cited in our briefs, 283 Kansas at 436. Of course, we all know the primary rule of construction of a contract is to determine the party's intent. And if the terms are clear, we determine the intent from the language of the party's agreement, and we don't use any rules of construction. Again, that's the Anderson decision and the Butler National decision, the decision of this court, 30 Canap 2nd, 540. Only if the language is found to be ambiguous or doubtful in meaning do we attach a presumption of arbitration and resolve any doubts in favor of arbitration. Mr. Kaiser said that the rule is we must resolve doubts in favor of arbitration. There are some cases that could be read to indicate that, but I don't think that's the accurate statement of the law. I've looked at the Hague case, the Anderson case, and then a recent decision of this court, Birch, which is a 2018 decision, 2018 Westlaw 6427293 at star 8, which brings all this together in a recent statement. Here, there's been no demonstration that the language in the side letter agreements arbitration clause or the operating agreement's arbitration clause is vague or ambiguous. So we don't even go to that rule of construction. We apply the arbitration clauses as the parties intended, as stated in the clear language. Waterwalk has failed to show any doubts or ambiguities as to language, and we don't need to go down that road. I would conclude, Your Honors, this court has said on many occasions that a party cannot be compelled to arbitrate any dispute to which they have not agreed to arbitrate. Waterwalk wants you to force Ms. Auer to arbitrate matters they never agreed to arbitrate relating to her employment relationship and the compensation she's due for those services. We would ask that this court affirm the district court's judgment that this present dispute is not subject to arbitration and return this case to the district court where these issues can be resolved. Thank you.
Thank you, counsel. Mr. Kaiser, you have 3 minutes.
Thank you, Judge Gardner. Appley's argument is sort of premised on the notion that Ms. Auer is not an owner, she's merely an employee, and that this is merely a contract and that does not contain an arbitration provision. With respect to the first question, and I think a useful example here as lawyers would be the difference between an associate and a partner in a law firm. You can leave the office, your particular office on December 31st, 2020, and assuming that partnership takes effect on January 1st, you can come to work the following day, come back to the same office and work on the same case, but yet there'd be a radically different, or your status with that or relationship with that organization is radically different. You are no longer an employee, but rather you are an owner. And that's the same thing that happened here. In October of 2014, Ms. Auer was an employee, but that radically changed. Ms. Auer would like for you to just ignore the fact that the side letter was signed, but the side letter was signed. And if you go to paragraph 8, it says, and I quote, "You will be required to execute simultaneously with your acceptance of this side letter and prior to the issuance of any units, the operating agreement." So this is not like the unpublished case from 2004 that Ms. Auer has cited to repeatedly, where there's this vague reference to future disagreements. The operative provision, the operative agreement that Ms. Auer's claims are entirely based upon, which is the side letter, specifically says in paragraph 8 that you are going to reference the operating agreement. Now, it would be convenient for us to simply just close our eyes and say, well, I'm going to ignore paragraph or section 7.05, but we can't, because it's specifically incorporated, full-throatedly incorporated into the side letter. And as a result, you're then stuck smack dab in the middle of deciding whether or not this dispute falls under any claim and whether or not this is consistent with the maximum extent permitted by law to enforce arbitration in this particular case. Now, I understand that some may disagree and say, well, I read it differently. Well, that is fine. But at that point, there's a disagreement, a reasonable disagreement. And then we're stuck with the case law that Mr. Casey has referenced. I don't think you can just simply say that contract law is supreme over this. Packard is clear. It says, and I quote, "All doubts concerning the scope of arbitratable issues should be resolved in favor of arbitration," end quote. Hague says, quote, "Unless the arbitration clause is not susceptible of any interpretation that covers the disputed issue," end quote, "then it must be arbitrated." Okay. At a minimum, absolute minimum, the fact that we reference the reference the operating agreement, which has a very clear, very broad arbitration provision. You cannot say that you cannot read this in such a way for this to apply to Ms. Auer. And again, I want to go back to this notion, which we sort of started off with. And again, I don't want the court to be left with the impression that we're relying on the side letter as the thrust of our arbitration provision. The operating agreement is clear. We think that the repurchase agreement, paragraph 3, supports our interpretation. But again, the bulk of it is through the operating agreement, which is specifically referenced. And we can come up with hypotheticals of what if Ms. Auer had not signed the side letter. Well, based on paragraph 8, then this deal would not have gone forward. All right, and we just can't gloss over. Judge Schroeder, you make a great point with respect to guaranteed payments. There is a difference. There's a significant difference between wages, especially from a KWPA standpoint, of wages versus guaranteed payments. You don't give guaranteed payments to employees. You give guaranteed payments to owners, and specifically in the context of an LLC, owners of an LLC. So you can't sort of just gloss over this. And if you look at plaintiff's response to our answer to our counterclaims, they specifically agree that Ms. Auer did file K-1, received a K-1, not a W-2. That's significant. So this whole notion that somehow she's just an employee on the left hand and she's a owner in the right hand, and you can separate out these two things, you can't. Those are one and the same, and it's clear from the side letter when it references guaranteed payments.
Counsel, you're exceeding your time. Can you wrap
Yes,
it
Your
up
Honor.
unless, okay, judges, do you have any other questions?
I do not. Thank you.
Okay, thank you both, counsel, for your good briefs and arguments. We'll take the case under advisement and get you a decision when we can.
Thank you.
Thank you.